Divorce, also known as a dissolution of marriage, is the end of a marriage before the death of a spouse. In the United States, it is projected that 31% of all marriages end in divorce. The foremost causes of divorce are financial issues, midlife crisis, affairs. If you find yourself in need of filing a dissolution of marriage, you may want to seek qualified representation. Often I'm asked, can I just represent myself? Can I do my own divorce? You may be able to. You may be able to obtain the forms, fill them out without any question. Sometimes people are confused. They're not sure of how to fill things out. They don't have the time to stand in line at the self-help center and find that it is easier to hire someone with experience that knows their way around the courtroom, that practices in the county where they live each and every day, and is able to obtain a fair and equitable divorce. There are two types of divorce. There's a summary dissolution and, for lack of a better word, a regular divorce. In a summary dissolution, that is for someone who has been married less than 5 years, they don't have any children, they don't own any property, and they do not have any disagreement about obtaining a dissolution. Both parties would fill out the summary dissolution packet and together file it with the court. If one of the parties has a change of heart, there is a document that is filed with the court that stops a summary dissolution. It is for this reason that when clients come to me and ask me, should I file a regular divorce or a summary dissolution, I will sometimes suggest that you go ahead and file the regular dissolution. This way, if someone has a change of heart, your proceeding can still go on. You will not need to start all over, pay a different filing fee, get the parties served, etc. In a regular dissolution, it takes 6 months and a day to obtain a divorce. That is because California has the 6-month and 1-day waiting period to see if perhaps counseling or the couple reunifies. After the 6-month and 1-day period, if everybody is in agreement, we can submit your agreement. If an agreement is not reached, we can proceed to trial. In a regular divorce, the proceeding starts by someone filing a petition for dissolution of marriage. This person will be called the petitioner. The petitioner then needs to assure that the other spouse is served with the divorce papers within 30 days. The other spouse will then file a response, and the other spouse will be known as the respondent. There will be an investigation period in which the parties will exchange financial information about assets and debts. At that point, once financial information has been exchanged, I invite the other side to come and meet in my office to see if an amicable agreement can be reached. If an amicable agreement can be reached, it will be typed up, signed, and submitted to the court. If an amicable agreement cannot be reached, then your matter is termed contested. A document is filed with the court that lets the court know that we are ready for our 3 court hearings, our trial setting, our mandatory settlement conference, and if necessary, the trial. A mandatory settlement conference is a court date. You will arrive in court, you will go into the courtroom, and the judge will direct the parties to go out and see if you can work out an agreement. It is for this reason that in my practice, I hold a voluntary settlement conference in my office in order to see if the parties can reach an agreement. Sometimes there is a partial agreement and the parties decide that the court will need to decide the remaining issues. The parties will have another shot at the mandatory settlement conference. If the parties still cannot reach an agreement at the mandatory settlement conference, the case will be set for trial. If you find yourself in need of filing a petition for dissolution, or if you've been served and you need to file a response, contact the Orange County Family Law offices of Yanez and Associates. We have experience and we will assist you in obtaining a respectful divorce that is equitable in the division of assets and debts.